This is Paul Turner, the Immigration Barrister at Imperium Chambers. If you've got an immigration problem or a query, get in touch with me and I'll do my best to help you. Also, it'd be helpful if you could subscribe to my channel and hit the notification button. Today's video is going to be discussing an important new case on the approach the court should take when considering the deprivation of someone's British nationality. The case is of more importance than perhaps it was many years ago, as the Home Office have been increasing the number of deprivation cases. In my experience in particular to Albanians / Kosovans who have lived in the United Kingdom for 20 plus years and who arrived when young and gave the wrong nationality. The latest case, Masija, deprivation reasonably foreseeable consequences, it makes it clear that the reasonable foreseeable consequences of deprivation of British citizenship do not include predicting the outcome of a subsequent human rights appeal. The case concerned an Albanian national who obtained refugee status and subsequently citizenship by pretending to be Kosovan. Mr. Muslija, and I probably apologise to him for his name, admitted his deception. The key issue was whether depriving him of his British citizenship would disproportionately interfere with his right to private and family life with his British wife and daughter. The Court of Appeal had previously heard that and you'll forgive the expression, proleptic analysis of removal should be avoided in deprivation cases. The word proleptic is a little unusual. The upper tribunal has helpfully provided a definition for the word proleptic. And it means, proleptic in this context means an anticipatory analysis of an individual's prospective removal or deportation, i.e. looking into the future. In essence, a decision depriving someone of their British citizenship doesn't necessarily lead to removal. There is in fact a two-stage process if a deprivation appeal is unsuccessful. First, the person will then be deprived of their British citizenship. They retain this until the end of the appeal process, and then they will become subject to immigration control, as per the 1971 Act. Secondly, the Home Office will then decide whether to grant a visa to the person, for example on human rights grounds. If the visa is refused, there is generally and almost certainly going to be an independent right of appeal to the first-tier tribunal. At the first stage, only the reasonably foreseeable consequences of deprivation can be considered. This includes what will happen during the limbo period between the deprivation and the decision on whether a visa will be granted. It does not include considering the potential outcome of the second stage and the likelihood of removal. The first-tier judge in the appellant's case failed to follow this approach. He considered whether the requirements of Appendix FM and Section 117B6 could be met and concluded it was extremely likely that he would win a human rights appeal. He decided that removal was not a realistic ultimate outcome. Deprivation was therefore disproportionate and the appeal was allowed. This decision was appealed by the Home Office and it was overturned by the upper tribunal. And the reasons for this were speculations as to what the Home Office's future decision would be, and the outcome of any appeal against it is not permitted. The upper tribunal said the judge purported to decide the outcome of an appeal against a decision, human rights, that was yet to be taken by reference to an application that had yet to be made, which is the human rights application. This constituted a proleptic analysis of a chain of future events. This is outside the scope of a deprivation appeal. Now, turning to the remaking of the decision, the upper tribunal then proceeded to remake the decision and dismissed the appellant's appeal. It seems a little harsh because the appellant's case and concerns were summarised as follows. A significant part, and this is quoting from the decision, of the appellant's concern was the potential loss of all that he had sought to build up in this country, having arrived at a relatively young age, ostensibly as an impoverished asylum seeker. He'd subsequently battled cancer and established his own business to provide for his family. And it was said that the Secretary of State's decision would not only deprive him of his British citizenship, but also of his pride. Now, the Upper Tribunal has previously held that the disruption the deprivation of citizenship will cause to a person's day-to-day life is a consequence of their own actions, and without more, the loss of the rights previously enjoyed by an individual cannot tip the proportionality balance in favour of retaining the benefits of citizenship if it was fraudulently obtained. The question in these cases, and as I say there's more of them as they come along, therefore boils down as to whether there is something more which tips the balance. This could be delay, this could be the loss of the right to work, the impact on the person's child, amongst other factors. In the appellant's case, he had all three. However, he was still unsuccessful. He also argued that it was unfair to deprive him of his citizenship in 2022 because 11 years ago he had disclosed his true identity to the Home Office. However, the delay was due to the Home Office's misunderstanding of the law on nullity and deprivation rather than due to culpable inaction. It seems a little harsh to me. He would, as a result, lose the right to work, leading to financial hardship for him and his family. However, the tribunal found in his case that they would be very unlikely to become destitute as his wife also had an income. When they looked at the best interests of the appellant's daughter, referred to as M, they basically said that the status quo ought to be preserved, but there would be limited impact on him losing his British citizenship on her, and her best interests were only marginally in favour of retaining the status quo, i.e. him winning. And the tribunal also said that length of residence alone is not a reason not to deprive someone of their citizenship. The cumulative factor in favour did not outweigh the Secretary of State's decision to deprive him. The appeal was therefore dismissed. The question therefore is, what tips the balance in favour of winning a deprivation appeal? In relation to delay, culpable inaction by the Home Office may be sufficient. This tipped the balance in the Court of Appeal case of Lachi and the Secretary of State for the Home Department in 2021. In that case, the loss of right to work was described as a factor of real significance in his case. However, that was not enough, as I say, for the reasons I've given in this particular case. However, it doesn't prevent it being relevant in other cases. This case failed in part because his wife did have an income. It may be sufficient, for example, where the loss of right to work will lead to destitution, or it's not possible for someone to run a business during the limbo period, during the process of the human rights application being considered or any appeal. Similarly, although not enough for the appellant in this case, the best interests of a child may also tip the balance in other cases. For example, where uncertainty caused by the parent's deprivation of citizenship would interfere with vital school exams, lead to a deterioration in the child's mental health, or interfere with the child's cultural identity and sense of self, then that may be something that tips the balance in favour of winning a deprivation appeal. Finally, it's important to look at statelessness. When considering a deprivation appeal, the Secretary of State can't deprive them of their citizenship if it's going to render them stateless. So this is something that is also worth considering. It's covered under Section 40, subsection 4 of the British Nationality Act 1981. If anyone is facing deprivation or deprivation order, then you should get in touch with me or another reputable lawyer as soon as possible, because the sooner you act, the better you will have, the better the chance you've got of winning, because you'll be in a better position to put forward your case. The longer you leave it or pretend it's not happening, the worse the consequences can be. It's unfortunate the appellant lost in this case. They could have won. They didn't, for the reasons that were given by the Upper Tribunal. But it does set out the law as it stands in relation to deprivation. It's complicated, it's complex, it can be very trying for an individual. But as I say, if you're facing it or you think you might be facing it, then do seek advice either from me or, as I say, from another reputable lawyer. I hope this video concerning the recent case law development has been interesting. Please subscribe to my channel, please hit the notification button, and please stay safe. Thank you again. This is Paul Turner, the Immigration Barrister at Imperium Chambers.